Our next speaker, Joshua Prince, Chief Counsel of Civil Rights Defense Firm, where he concentrates on dedicates his practice in the area of defending his clients' constitutional and statutory rights under state and federal laws. He saw a need for a firm specifically dedicated to the inalienable right to keep and bear arms. He formed Firearms Industry Consulting Group, where he's the chief counsel and represents clients with state law issues in Pennsylvania and Maryland, and with federal issues across the United States. He's represented over 4,000 individuals, 500 federal firearms licensees, and several dozen gun clubs and ranges on various state and federal issues. Joshua has also taught numerous continuing legal education seminars on firearms law for the Pennsylvania Bar Institute, local bar associations, and even the NRA. So I think this is the topic where I think everybody is kind of looking forward to hearing about, because it's constantly an issue about weapons in the house of worship. He's going to look at it from the legal perspective, and again, we'll leave some time at the end of the presentation for questions and answers. Joshua?
Thank you. Good afternoon. How's everyone doing? Can you hear me well? So? All right, let's try it up a little higher. Is that better? All right. So before I really get into what I want to discuss with you tonight, or this afternoon, I want to ask if any of you visually assessed me when you saw me for the first time. It's okay, right? You can raise your hands. I'm not going to be offended. I'm actually going to be offended if you didn't assess me. So everyone raises their hand, right? I assessed all of you. In fact, so far today, I've seen 8 of you carrying concealed in a traditional carry mode, meaning on your right or left hip. And 2 people I confirmed were carrying appendix. There were some other people I wasn't sure of, but I'm pretty sure that I've now seen 8 people carrying. I generally know in this type of audience that those are people I can probably rely upon if issues would arise. But you've got to be constantly assessing the situation. Why did you dismiss me? Is it because I'm in a suit? That's the wrong answer. You never know who the attacker is going to be. Did you look at what I was carrying? I've been carrying around with me all day my briefcase. Well, you'd assume an attorney has a briefcase, right? If you thought I was an attorney. Did you look at my briefcase? It's not your typical lawyer's briefcase. It has mole pouches on the outside, very militaristic. Is that maybe a red flag? Is that something you should have been concerned about? Maybe. If you had been watching me, you would have noticed that numerous times during the different talks, I got up and left my briefcase here on a seat, and I made sure to place it up on my seat so anyone could see. It's not hidden next to the side. So far, I didn't get any complaints from security. No one complained or raised concern about it. If you knew I was a lawyer, wouldn't you think it's a little unusual for me to leave my briefcase on my seat when I leave the room? You know, usually lawyers are carrying around confidential information. Isn't that a red flag? No one seemingly picked up on it, and I did it numerous times just to see if anyone would. Maybe worse yet, when we were at lunch, I took a seat up front. Everyone could see me. Put my food down. Put my briefcase again on the chair so everyone could see it, and I walked out of the room in front of the whole line of people that were waiting to get their food, in front of all the people that had already sat down. Again, this militaristic-looking briefcase. No one said a word. You have to be aware of your surroundings. You don't know who I am or what my intent was. Maybe now you do, or maybe some of you do know me in my background, and you do know that that's my typical briefcase. But these are the types of issues that you do need to be aware of. You can't be lulled into a false sense of security. And that's true as well with gender. Generally, when I talk with individuals, when they are assessing potential threats, it's always males. They're always focused on the males. They never look at the females. They never look at the kids. It's a scary time that we live in. And I know there's some organizations that are doing training, including with sheriff's departments in that, and courthouse facilities and other sensitive locations. And now one of the main training things is using children. Because no one thinks about that. Kids got a suicide vest attached to them. You have to remember to always stay vigilant and be aware of your surroundings, regardless of the skin color, sex, anything, because you never know where that threat's going to come from. So with that being said, let's go into what I'm really here to talk about. Of course, as any lawyer, I have to throw up a disclaimer. And it's actually not because I want to. It's extremely scary to me that the case law evolves at such a fast pace anymore that I can't even keep up with it, and my sole area of practice is firearms law. The days of being a general practitioner are long gone, in my opinion. There is no way for an attorney to properly advise his or her client if that attorney doesn't have an area of focus, and that's the topic that they're discussing, because it is that scary. I could tell you what the law is today, and on Monday, we could get a court decision that turns that on its head. And that's why I always tell all my clients it's important to have an attorney involved to be able to advise you, especially in these times where the law evolves at such a fast pace. So be aware of that. We're going to go over some statutory provisions. I am going to go over some cases as well. But again, just remember, it's good law as of today, but as of Monday, that all could change. And quite honestly, there could have been a decision that came down on Friday that I'm unaware of that could change something that I'm telling you here today. That's why I always say it's very important to make sure that you have competent counsel that can advise you. The other issue I want to just bring to your attention, we are not going to review all the legal issues that you need to be aware of as a house of worship that allows firearms or other weapons on your grounds. When I do a state and federal firearms law seminar, I usually teach it for 4 hours, and I don't get through all the material that I want to get through. And even if I did, quite honestly, it probably only touches upon 65 to 70% of the law that applies to individuals on a general basis. There are plenty of issues that just don't generally arise, so we don't go over them, because there would never be enough time. I could probably do an 8-hour seminar and still not get through everything. That's how complex our laws are, especially when you factor in the federal laws. The other thing I will tell you is when you leave here, you will likely know more about what constitutes a prohibited person than 99% of the criminal defense bar here in Pennsylvania. So let's get to it. So here's a little bit of an overview of what I'm going to discuss with you today. We're going to talk about the lawfulness of weapons on grounds of houses of worship in Pennsylvania, restrictions on churches, synagogues, mosques, etc., restrictions in and on school grounds. I know that's an issue that many of you have raised previously. Restrictions on other locations. Is there other places that we need to be concerned about? And yes, there are here in Pennsylvania. Then we're going to talk about Act 235, the Lethal Weapons Training Act of Pennsylvania. Act 235 is a lot easier to say. To whom does it apply? You might be surprised. It may raise some issues that you need to be aware of and address in your house of worship. Even if it doesn't apply, should you have your Security Personnel Act 235 certified? There may be good reason to do it. We're also going to very briefly touch on Pennsylvania's Private Detectives Act. Then we'll move on to security personnel. Are you sure your security officers aren't prohibited persons? Are you really sure? And then we're going to close it out on use of force in Pennsylvania, talk about, can you stand your ground in Pennsylvania? Can you stand a third party's ground in Pennsylvania? And lastly, the civil immunity that exists here in Pennsylvania. So, restrictions on churches, synagogues, mosques, other locations. How many here think that there is some form of prohibition here in Pennsylvania on that? Oh, you already read it, right? It's okay. In other states, it's very different. Here in Pennsylvania, we have no state prohibition on an individual having any form of firearm or other weapon in any type of religious institution, provided it's not otherwise a prohibited place, and we'll talk about those in a minute. But generally speaking, it's completely lawful. However, and you can see, let's see if I guess the red dot doesn't work. Okay. However, private property owners can restrict on their own property. So as a religious institution, you may want to restrict people or congregants or other individuals from being able to possess a firearm or other weapon on your grounds. So that's something to be aware of. Another issue that's coming up more frequently now is we see multiple organizations sharing space at one facility. Well, you have to look to any restrictions in your lease or your agreement with the institution that owns that property. Make sure they don't have any restrictions that they're imposing on you in regards to possession of weapons at that facility. So just keep that in mind. What about school grounds? Let's first talk about federal law before we get to state law. So under federal law, it is unlawful for an individual to possess a firearm or ammunition within 1,000 feet from grounds of a public, parochial, or private school. Okay, that seems pretty clear. It is 1,000 feet from the outer boundary of that school, so where it ends, you would go 1,000 feet from it. There are a number of exceptions to it. First, you have a Pennsylvania license to carry firearms. That is your concealed carry permit here in the Commonwealth. It's important to understand that federal law is very specific in this regard. It says that you must have a license to carry a firearm from your state where the school exists. So let me give you an example. Pennsylvania has reciprocity with Florida. So someone who is a Florida resident who has a concealed carry permit in Florida can come up to Pennsylvania without getting a Pennsylvania license to carry and rely upon that Florida license. With federal law, it's very specific that it must be a license issued by the state where the school is found. I am not aware of any cases where someone was prosecuted for this where they had a reciprocal license, meaning that they had a license from Florida, didn't have a Pennsylvania license, and were found on school grounds here in Pennsylvania and were said to be violating the act. But it's an important issue for me to raise. The other issue I will mention to you is that the school gun-free zone was previously held unconstitutional by the U.S. Supreme Court. The Congress then reenacted it, and since its reenactment, I am not aware of any challenge to its constitutionality, and I think based on the prior Supreme Court case, the new enactment may suffer the same fate of being unconstitutional. Quite honestly, I have not really seen the gun-free school zone charged in many situations across the United States. So I don't know how active the enforcement is of it, but still, you need to be aware of it. Another exception is if you're a law enforcement officer in the scope of your official duties, you're on private property. So if your house or your business is within 1,000 feet of that school grounds, that is an exemption from the law while you're on that private property. The firearm is unloaded and is contained within a locked container in the motor vehicle. So if you don't have a license from your state to be able to conceal carry a firearm, then the firearm must be in a locked container separate from the ammunition. Just make sure you understand that it must be a locked container. Or is possessed for a school activity or related to a school contract. Obviously, some of you are aware that we do still have some school shooting teams here in Pennsylvania, and obviously we don't want those kids to be in violation of the federal gun-free school zone merely because they're part of a school shooting team. Let's talk about state law. So here's where it gets complex, and I actually litigated a case regarding this that we're going to talk about in the next screen. For our purposes, under Section 912, It says a person commits a misdemeanor of the first degree if he possesses a weapon in the buildings of, or on the grounds of, or in any conveyance providing transportation to or from any elementary or secondary publicly funded educational institution, and it goes on, pretty much any school. Does that surprise any of you? A lot of people think that you can never have any form of weapon on school grounds, and if you actually look to the definition of weapon, it's anything capable of inflicting serious bodily harm or death. Now, I'm going to talk about the Gosselin decision in a minute, but in researching the types of incidents that occur on school grounds, it is amazing to me that kids can even have pens and pencils anymore in schools, because I came upon so many occasions where a pen was used against another student that it floored me, quite honestly. I never thought there was that much of an issue. And when you start thinking about any weapon that could possibly result in serious bodily injury or harm, and you start thinking about all the objects in schools or that are on buses or in cars that go on school grounds, that's a scary thought. Because almost anything anymore could cause serious bodily injury or harm. I mean, the baseball bat for the baseball team, the scissors at the art studio. I mean, it's just all-encompassing when you think about it. So, I said I litigated a case. What's the exception? There is a defense, and it says, it shall be a defense that the weapon is possessed and used in conjunction with a lawful supervised school activity or course, or is possessed for other lawful purpose. Now comes the Gosselin decision. Let me give you the background. Well, let me read you what the Superior Court ended up holding, and then I'll give you the background. So in Commonwealth versus Gosselin, the Superior Court en banc, which, for those of you who don't have a legal background, means the entire Superior Court. An en banc court means from the entire court. Generally, with a court of appellate jurisdiction, you have a panel of usually about 3 judges. An en banc decision means, again, that it comes from the entire court instead of just a 3-judge panel. It has the most binding precedent that can exist from a court. So there, the Superior Court held that the language, quote, other lawful purpose, expands, quote, the defense to include any additional or different lawful reason not otherwise mentioned in the first clause of Section 912C, regardless of whether it is school-related. So here is the background to the Gosselin decision. Mr. Gosselin and his son go out the night before, and they're whittling sticks. The son, like any good son, has his Swiss Army pocket knife that he's whittling sticks with, and when they go home, puts it into his pocket, as he always does, and like any good young man, he decides to wear the same pants the next morning to school. And he gets to school and realizes that he has this Swiss Army knife in his pocket. He does the responsible thing. He self-reports himself to the teacher. Says, look, I didn't mean to bring this Swiss Army knife onto the grounds. I didn't remember. I was out last night whittling sticks with my dad, and I put it in my pocket, and I'm wearing the same pants, and I wanted to let you know. So what's the school district do? Oh, we got to expel you. So they want to hold a hearing to expel him. So they call Mr. Gosselin and say, we need you to come down to the school right away. We need to hold a hearing. Your son was found in possession of a knife on school grounds. Mr. Gosselin's at work. He's a carpenter. He comes immediately to the school. They go into a meeting, and without going into all the specifics of what occurs there, basically at one point in time, they keep saying that the son is in violation of a school policy. It's never said in violation of law, always a school policy. And because he had possession of this knife, this Swiss Army knife, on school grounds. And at one point, Mr. Gosselin reaches into his pocket and basically pulls out his knife that he uses for his carpentry, puts it on the table saying, Are you telling me I'm in violation of the policy? There's a couple different accountings of what happened. There's a snowflake accounting and there is a conservative accounting, both from officials with the school district of a high up regard. There is no dispute by anyone that he never pulled out the blade and that he never pointed it at anyone. One account is that he slammed it down on the desk. The other account is that he just set it down on the desk. The person who says he slammed it down on the desk is still having emotional issues from this, allegedly. Anyway, at that point, when the school says yes, Mr. Goslin, again, no dispute about this, takes his pocket knife, just slips it sheepishly into his pocket and says nothing more about it. They call the Pennsylvania State Police, and Mr. Goslin is charged with having a weapon on school grounds. He gets counsel that isn't the best. During the trial court, there were a bunch of issues that were overlooked and not addressed, and unfortunately, the trial court finds him guilty. And what the trial court says is that any purpose of having a weapon on school grounds must be related to a school course or activity. And since he wasn't there for any school course or activity, then it's prohibited. And this is absolutely abhorrent. Unfortunately, Mr. Goslin doesn't have a lot of money. And so he appeals the decision himself, pro se. And he does a decent job. For a layperson, I have to say he did a phenomenal job. He didn't know all the issues to raise and how to do proper research, but he did a really good job writing his brief. And what happens is the Superior Court, a panel of the court, comes down with a decision saying, yep, we're affirming what the trial court said. And said because Mr. Goslin didn't have the knife of his son, he wasn't bringing the knife there as evidence of the crime to argue something or something like that, it wasn't related to any school course or activity, we're going to affirm the decision of the trial court. There was one judge who dissented and said, look, I really don't like what the statutory language provides, but it is not my job to decide what the law should be. We are supposed to enforce the law as it is. And I believe the other two judges' decision is in direct violation of what the law requires us to do. I saw this decision come down. I reached out to Firearm Owners Against Crime, which is a huge statewide organization, and they were able to make contact with Mr. Goslin. And I offered to represent Mr. Goslin pro bono in asking the Superior Court to reconsider its decision. And he was more than happy to have me do that. Obviously for him, it was a financial situation that he was in. So I filed a motion with the court asking it to reconsider the decision, to vacate the prior decision, to allow me opportunity to brief the issues, and to give me opportunity for oral argument. And to my surprise, and I honestly say that, it was surprising, the court granted me everything I asked for. I did not previously have the court vacate a decision. I've had the court previously grant reconsideration, but never vacate a decision before it issues its final reconsidered decision. So I started working on my briefs, and you'll notice if you look at the defense, there's actually two separate categories, and that is what the one dissenting judge had said. Because if you look at the first part of the sentence, is there anything that jumps out at you? There's actually two different verbs being used. If you look at it, it's a defense that the weapon is possessed and used. Now, if we look at the second clause, we have or is possessed. There's no use. Why is that? Because the clauses are separate clauses to provide different abilities. The General Assembly understood when they were enacting this defense that there were school shooting teams. And so they needed the ability not only to possess the weapon, but also to use it. Someone otherwise possessing it for a lawful purpose shouldn't need to use it. If they did, then there's a separate defense called justification that would apply. So a defense on top of a defense. But that's why there are different verbs. And I pointed that out to the court. We also pointed out to the court the issue that otherwise, you're saying that single mother who has to drop her child off on the way to work in the morning is going to be precluded from being able to possess any form of weapon capable of inflicting serious bodily injury or harm. That includes even a stun gun, electronic incapacitation device, as we call it here in Pennsylvania, for the remainder of her day because she has to go on school grounds to drop her child off. And we gave a bunch of other examples of how this was not what the General Assembly intended. I even researched it. I was able to bring up the debates that occurred when they enacted this. And it was clear that the General Assembly was attempting to address situations of student-on-teacher violence. And they even said they weren't concerned about third parties coming onto the school grounds. Thankfully, we got a great decision back from the Superior Court en banc that now said, yes, this was wrong. Mr. Gosselin absolutely had the right to the defense of possessing it for a lawful purpose. And if you actually look at the transcript during the trial court hearings, he had testified that he uses this knife for his carpentry work. He also has it to open cans of tuna when his wife gives him tuna for lunch, and some other lawful uses. There was nothing reflecting any unlawful use. What's important to point out is that it is a defense, meaning that technically the district attorney or the police can charge you with it and force you to have to prove as a defense that you possessed it for another lawful purpose. Now, since the Gosselin decision came out, I'm aware of 28 incidents where either a law enforcement officer wanted to charge someone for having a weapon, not just firearms, but just all forms of different types of weapons, on school grounds, and the district attorney told them, no, you can't because of this, because we think he'd be eligible for the defense. Or where the officer brought charges and then the district attorney had them dismissed. A good district attorney is going to look at the background to the situation, assess whether the person has a reasonable likelihood of being able to prove a defense, and if so, not to bring charging. Now, legally speaking, it's not required. It is a defense to be proven, but what we are seeing consistently is district attorneys are looking at these situations and generally not prosecuting people where they're on school grounds for a lawful purpose, and that makes sense. So be aware of that. So what does this decision really mean? As long as you're in lawful possession of a weapon for a lawful purpose, and I have i.e. self-defense, and I would highly recommend whenever you get your license to carry or that, there's a couple different check boxes for a reason that you want your license to carry. Check off self-defense. You may claim the other lawful defense. And I know they're going to email out the PowerPoint presentations. I have a link there. You can actually see the article I wrote on the Gosselin decision where I go over all this in a lot more detail. So where else are we restricted in having weapons? Court facilities, but they have to provide lock boxes. Detention facilities, correctional institutions, or mental hospitals. Well, that makes a lot of sense. I don't think any of your houses of worship are at any of those locations. Long guns on the street or property in Philadelphia, unless the person has a license to carry firearms. Again, I don't think that's a big issue for you guys. Veterans Affairs facilities. Again, I put this up there so that you have a little bit better of an understanding, not necessarily going to apply to you in everyday life, but the important aspect of this is it includes national cemeteries that are run by the VA. So keep that in mind. Certain Department of State buildings, it's a regulation that would seemingly be unlawful under Section 6109 M.3, but it's still on the books, so I list it. So let's go on and talk about Act 235. So, to whom does it apply? Because there's a lot of misinformation about Act 235 out there. Privately employed agents include any person employed for the purpose of providing watch guard, protective patrol, detective, or criminal investigatory services, either for another for a fee or for his employer. So we see a lot of talk about employer, employment, being employed, And we also see discussion about receiving a fee for your work. Also, if we look down, we'll see all privately employed agents, except those who have been granted a waiver, yada, yada, as an incident to their employment. So we see this theme talking about employment, and that is really the crux of Act 235. Are you being employed, or are you receiving some form of tangible benefit for your services? What does that mean? If your security personnel are being paid in any form, including ostensibly through a non-tangible benefit, i.e. reduction in or waiver of any dues, just to give you an idea, they must be Act 235 certified because they're receiving some benefit for providing you with that service. Well, maybe you don't provide them with any form of tangible or intangible benefit for being security personnel. What then? Why might you still want them to go through Act 235 training? Well, there is a background check that is performed on them, whereby if they happen to be prohibited from purchasing and possessing firearms and ammunition, they will be denied. They also have to go through a psychological test to determine their psychological makeup. And I can tell you from my own experience, having represented two people now with this situation, the PSP, just because your psychologist signs off on you, does not mean that the Pennsylvania State Police is going to approve you for Act 235 certification. I have had situations where clients have been on certain prescribed medications by their doctors where the Pennsylvania State Police psychiatrist didn't like those medications and said, I don't think they should be able to be Act 235 certified because, in my opinion, if they're on those medications, it may limit or otherwise affect their judgment. And so we've had to deal with those situations. Sometimes that means that my client's going to have to change medications to one that the Pennsylvania State Police psychiatrist would approve of. It really depends on the situation, but there is a very thorough background check done and psychological check done on the individual. One of the issues that's obviously going to rise with any Act 235 certification is who's going to pay for it. If the person's going to be approved through the whole process, the fees are going to be $102.60 before payment for any psychological examination. Quite honestly, you could easily have $500 or so or more wrapped up in having a single individual Act 235 certified. Is that a cost you want to incur? It's something you need to think about. I do have a website there for the Pennsylvania State Police where they have more information on the Act 235 certification process, so if you have questions or that, you can reach out directly to the Pennsylvania State Police. What about Pennsylvania's Private Detective Act? So this was actually raised when we were planning this class. One of the planners brought this issue up to me. I don't believe it applies in the least. However, I am cognizant of the fact that the statute is extremely vague and there is absolutely no case law on it. So what it says is generally if there is some sort of private detective activity occurring, which could be just for your employer, that you're likely going to have to be certified under the Private Detective Act. It does exempt, though, under Section 25, any charitable or philanthropic society or association duly incorporated under the laws of the Commonwealth and is organized and maintained for the public good and not for the private profit. That's why I always have believed that the Private Detectives Act does not apply in these situations. However, if you are going to have individuals as security officers in your facility, I would highly recommend reaching out to the district attorney in the county in which your facility is located and making sure that the district attorney agrees with that interpretation. Because the last thing you want to find out is that the district attorney takes a different position after there's an incident there. Again, I don't see how it really should apply, but there is no case law, and the statute is so vague that it's at least one that I think it warrants reaching out to your county district attorney to make sure that they don't have a different interpretation of the law. So are you sure your security personnel aren't prohibited persons? As I mentioned when we started this, most of you are going to leave with a better knowledge of Pennsylvania's firearms laws than 99% of the criminal defense bar here in Pennsylvania. We're going to talk mainly about the federal prohibitors that attorneys never even consider. Most state attorneys that try to determine if someone is prohibited only look to state law. And quite honestly, in my experience, I would say probably around 70 to 80% of individuals become prohibited long before under federal law than under state law, meaning federal law is far more encompassing and restrictive than state law is. There are one or two exceptions to that, but again, generally speaking, federal law is going to be most restrictive. So obviously, if the person's a fugitive from justice, that's pretty self-explanatory. There's no real reason to need to discuss that. An unlawful user of or addicted to any controlled substance. This we need to talk about, because I'm sure many of you are aware that Pennsylvania is now a medical marijuana state. Marijuana is still federally prohibitive. A doctor cannot prescribe marijuana here in the Commonwealth because DEA controls a doctor's ability to prescribe drugs, and if they were to prescribe an illegal substance, they would lose their licensing. That's why, even under Pennsylvania's Medical Marijuana Act, doctors don't prescribe it. They basically recommend that a patient get it, and if they fill out forms for the patient to be able to get a medical marijuana card, and then that is the basis for that individual to be able to go into the dispensary and procure marijuana. It's scary to me that within the first 2 weeks of the dispensaries being opened up, they were without product. They sold out completely. Also, there have been some misstatements, I'll say, by the governor's office regarding this. It is federally prohibitive. It does not matter that Pennsylvania has authorized it. While Governor Wolf has more recently stated that he will not have the Pennsylvania State Police prosecute people for this, you have to understand you're violating federal law. Nothing's going to preclude the U.S. Attorney's Office from bringing charges against you for being in violation of the law. Additionally, although there is nothing in the law or the regulations to this regard, the ATF, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, and FBI, Federal Bureau of Investigation, take the position that if you utilize marijuana, you are prohibited for a 1-year period of time from being able to possess or purchase firearms or ammunition. And that's important to understand. When we're talking about federal law, the preclusion applies to ammunition as well. So if you have a 500-round brick of 22s, that's 500 separate felony counts coming at you. Keep that in mind. Now, how would you know if your congregant is a medical marijuana user? Your one volunteer is a medical marijuana user. You wouldn't know because all the information is confidential. Now, maybe they posted a picture online, being real Mensa candidates, on Facebook of their card, and that's, or worse yet, they have a gun in their card. Yeah, that's real great. They got good, competent counsel. So you might be able to find out in that regard, but other than that, you're likely not going to know. Now, if you go through the Act 235 background check, they are definitely going to flag someone who is a medical marijuana user. I will also say if you've purchased a firearm recently, the ATF 4473 form, the form you fill out to purchase that firearm, has been changed. They now have in big, bold letters right under this question that the fact that your state has decriminalized or permits recreational use of marijuana does not change the fact that you are prohibited under federal law. Being an alien illegally in the United States or having been admitted to the United States under a non-immigrant visa, I don't think this is a situation you guys are going to frequently come into, so we won't really spend any time on it. just be aware that it is a potential issue if you do run into it. Has been discharged from the armed forces under dishonorable conditions. Some of you may remember this seemed to become an issue with the shooter in Texas. They were saying that he had an other than honorable discharge. I was actually, and quite honestly, surprised to learn that there's 5 different levels of discharge from the military. Only a dishonorable discharge in and of itself is prohibiting. So an other than honorable discharge, that is not prohibiting. A general discharge, again, not prohibiting. However, when I have the client come in and say, well, I had a general discharge, my work is not yet done for a reason we're going to discuss in a couple minutes, because usually if that person had something other than an honorable discharge, they were likely court-martialed. And if they were court-martialed for an offense that was punishable by more than 1 year in jail, they are prohibited. That is the issue that actually arose with the shooter down in Texas. It was not that he was dishonorably discharged, rather, beyond also being involuntarily committed, which was a prohibitor, he had been court-martialed for an offense where he could have been punished by more than a year. And that information was never relayed by the military to FBI. Having been a citizen of the United States, has renounced his citizenship. Again, not an issue I think you're going to come into frequently. One that I don't have on here before I talk about misdemeanor and felony crimes is mental health commitments. So if you've ever been adjudicated incompetent, think of that as a guardianship. If you've had a guardianship appointed, or a guardian appointed in relation to you, you've been adjudicated incompetent. There are other types of mental health disabilities as well. If you have ever been involuntarily committed to a mental institution, you are prohibited. I've litigated these cases. In December, I litigated a case that came to decision in the Western District Federal Court of Pennsylvania in front of Judge Gibson, where he ruled our first level of what he called examination evaluation, a 302 commitment, is not sufficient to trigger the federal disability. However, a 302 is a specific prohibitor under state law. The reasons for it is there's no due process provided. So I think the state law prohibition is unconstitutional as well. That's well beyond the scope of what we're discussing here today. The reason I bring it up is if you have reason to believe that someone was involuntarily committed, even at that first level, 302'd, they're likely prohibited at least some level until the courts step in and decide the constitutionality of those issues. So just be aware of that. And it can be as a juvenile. I have plenty of clients that at 14 years of age, they were involuntarily committed because their parents wanted to go away on vacation and did not have a babysitter. I have that now documented 4 occasions in the medical records. And now that person is prohibited for the remainder of their life, at least under the current interpretations of the law. So just be aware of that. All right, my favorite category, the category that no one understands, and I understand why. So how many of you think that a misdemeanor crime is a prohibiting crime? Okay, we don't have many, so I guess we can walk out of here. This will be easy. So actually they can be. In fact, it is very easy to become a prohibited person under federal law. So what does federal law say? Now, this is the textual definition. It shall be unlawful for any person who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year to purchase and possess firearms and ammunition. Well, that's pretty easy. All we need to know, there's 2 key words there. Well, 3. Needs to be convicted, needs to be punishable, not punished. It needs to be able to be punished by a term exceeding 1 year. Okay, so we got to look to the crime that the person was convicted of, determine what the maximum sentence could have been, and if it could have been more than 1 year, they're prohibited. Doesn't matter if they don't spend a single night in jail. All we look to is what is that maximum amount of time they could have been imprisoned for. But they had to define what a crime punishable by more than 1 year means. And they exclude out from the definition any state law crime of a misdemeanor nature that could have been punished by 2 years or less. So in certain situations, 1 means 2. You tracking this? I mean, they expect everyone to understand this. Okay, well, let's see if we can boil it down to something that you can understand. If we're talking about a federal offense or a felony, it only needs to be able to be punished by more than 1 year to be prohibiting. Doesn't mean it was actually punished by it. Only needs to be punishable by more than 1 year to be prohibiting. Now, quite honestly, while I'm only licensed in Pennsylvania and Maryland, I don't know of any state laws across the United States where a felony is able to be punished by less than a year. It's generally, or they're all punishable by more than, I should say, a year. So generally speaking, if someone's been convicted of a felony, you know that they're going to be a prohibited person. Federal offenses, most federal offenses do carry with them sentences where they could have been punished by more than 1 year. There are a couple exceptions to those. I've had to deal with those situations when courts erroneously report information to FBI. But again, general rule of thumb, if they have a federal offense or even a felony, they're going to be prohibited. I have a client right now who's prohibited because like a decade and a half ago, she made a false statement on a tax return. She had to plead guilty to it. She's prohibited from being able to purchase and possess firearms and ammunition because of it. Okay, so let's go back to the rule. If it's a federal offense or a felony, it only needs to be able to be punished by more than 1 year to be prohibiting. If it is a state law offense of a misdemeanor nature, it must be able to have been punished by more than 2 years. In Pennsylvania, what that means is, generally speaking, only misdemeanors of the first degree, our highest grade misdemeanor, are going to be prohibiting because they can be punished by up to 5 years in jail. There was only one exception to that rule that I was aware of that recently was repealed as cruelty to animals. It was graded as a misdemeanor of the first degree, but in the statute it said it could not be punished by more than 2 years. So it would not trigger that federal disability, even though it's graded as a misdemeanor of the first degree. A misdemeanor of the second degree is generally not going to be prohibiting because the maximum it could be punished by is 2 years. It can't be punished by more than 2 years. So misdemeanors of the second degree are mid-level misdemeanors, again, generally not prohibitors. Why do I keep saying generally? We're going to talk about domestic violence in a minute. Misdemeanor of the third degree, that's our lowest grade misdemeanor. Again, that is generally not going to be a prohibitor either. So that gives you a little bit of idea as to what is of issue. Now, I know I have it at the bottom, state law, but I want to talk about it right now. Usually, someone would not become prohibited under state law and not be already prohibited under federal law. One exception to that rule, because we're talking about misdemeanors, is where someone basically impersonates a public official, where that public official is a law enforcement officer. So we do not have a specific crime of impersonating public official -- law enforcement officer. The crime is impersonating a public official. So if you see that someone in your congregation who wants to be one of your volunteers has been convicted of impersonating a public official, your job's not yet done. That's only graded as a misdemeanor of the second degree, so it's not federally prohibiting. But state law says it is if you were impersonating a law enforcement officer. That means you're going to have to go to the court, you're going to have to pull the records, you're going to have to look to the affidavit of probable cause and see who was this public official that they were contending that this congregant was impersonating. Be aware of that. Domestic violence prohibitors. If you are convicted of any grade misdemeanor crime involving domestic violence, You are prohibited. So just keep that in mind. We have disorderly conduct, which can be either a summary offense, which would not be a prohibitor, or a misdemeanor of the third degree, that lowest grade misdemeanor. Because disorderly conduct involves a kick, punch, or shove, if it involved an intimate partner, as federal law talks about, guess what? You're going to be prohibited for life. There was a case, I think it was in 2003, I want to say, Pennsylvania State Police versus McPherson, where Mr. McPherson, years prior to that, gets charged with disorderly conduct, and the officer charges it as a misdemeanor of the third degree, not as the summary. He goes into the magisterial district judge's office and says to Judge, look, I don't know about hiring an attorney and all the cost I'm going to incur with all of that. If I just want to plead guilty to this, what type of sentence are you going to impose against me? Judge says, $150 fine, you plead guilty, you're done, you're on your way, and we're done with this. Okay. He says, well, that's far cheaper than the attorney is going to charge me, so pleads guilty. I think it's about 8 or 10 years later, goes to purchase a gun at Cabela's and gets denied. He says, what am I getting denied for? And this case ends up going all the way up to the Pennsylvania Commonwealth Court. That is one court below our Pennsylvania Supreme Court. But there, he says, well, look, how are you contending that I'm a prohibited person because of a domestic violence conviction? I only have a disorderly conduct offense, a misdemeanor of the third degree, and oh yeah, there was no trial. There was no evidence submitted. Commonwealth Court says, okay, well, you pose a good question here. While there was no trial and no hearing, we're going to look back to the affidavit of probable cause that the officer had issued, and there it suggests that you shoved your girlfriend at the time. So we're going to find that the intimate partner aspect is met. And he says, well, how are you going to find that there was violence? You got to find that there was violence. And if you look at disorderly conduct, there are 8 subcategories of different conduct, everything from obscene language to a kick, punch, or shove. I pled to the overarching just disorderly conduct. Court says you raise another good point. Unfortunately for you, you pled to the overarching crime. While no subsection was specified, again, if we look to the affidavit of probable cause, it should suggest that you shoved your girlfriend. So we're going to find that the violence aspect was met. He became prohibited basically overnight in his mind. The court said, had you maybe had counsel who was acutely aware of this and either was successful in getting the officer to change the grading to a summary where you wouldn't have been prohibited, or had specified a category that didn't involve violence, like obscene language, maybe then we'd reach a different conclusion. But unfortunate for you, that's not the case. More recently, right before Justice Scalia passed on, there was the U.S. Supreme Court decision in U.S. v. Castleman involving domestic violence. And this, again, was a very interesting case, and Scalia issued a scathing dissent. What the background was, it was actually a young lady who was being prosecuted for attempting to purchase a gun and being precluded because of an alleged domestic violence incident. And she didn't dispute the intimate partner aspect of it. She freely admitted it occurred with her husband, but she said, how could there possibly be any violence? All I did is mix antifreeze in with his iced tea. I never touched him. Never laid a hand on him. I just, swirled the spoon in the iced tea. And the Supreme Court came down and said, nope, that's domestic violence. And Scalia issued the scathing dissent that basically says now everything and anything is domestic violence. Lightest tug on the hair of someone who's an intimate partner, domestic violence. Why am I spending all the time discussing this with you? Because we have no particular offense called, quote-unquote, domestic violence. We have disorderly conduct, which may or may not be a violent offense that can trigger a domestic violence prohibition if it involves a domestic partner, an intimate partner. We have simple assault, Again, generally that's graded as a misdemeanor of the second degree, so it would not be a prohibitor. But in this context, if it involves an intimate partner, guess what? It's a prohibitor. You're not going to know if you look at court records necessarily whether or not that person is a prohibited person. If you look online, the AOPC has docket sheets that you can search to see, anyone who's been prosecuted, and you find that docket sheet, you're not going to know if they were charged with simple assault, who it was in relation to, or better yet, disorderly conduct. Are you really sure? So now that we've gone over that, and you know more than 99% of the criminal defense bar on when someone becomes a prohibited person, do you feel confident that you can determine if someone is prohibited? See, the one little tidbit that I left out so far is when we talked about mental health commitments. Yeah, that's not reported anywhere publicly. They're all protected by HIPAA. They're medical records relating to the person. You're never going to know if the person was 302'd or 303'd or 304'd under the Mental Health and Procedures Act here in Pennsylvania. You're not going to know necessarily if that offense they were charged with was a domestic violence situation. What about getting them Act 235 certified so that you can feel assured that they're good to go? It's a good idea. But you only know at that point in time, when they go through the certification process, that they were good to go at that point, because Pennsylvania State Police is going to deny them if they're a prohibited person. What happens when the day after certification, they get served with a Protection from Abuse Act order, PFA? Guess what? That's prohibiting under domestic violence as well. That's a civil aspect, a non-criminal aspect. How would you know about that? You wouldn't. What do you do? Well, maybe when you have these individuals volunteering or otherwise working, or depending on your situation at your facility, maybe you need an agreement that addresses that, where there is an obligation on their part to disclose to you if they have any type of mental health commitment or become a prohibited person under state or federal law, because that will at least give you some cover when that happens. I represent a bunch of gun ranges and gun clubs, and as they're taking in new members, they can't check to see if someone's prohibited. They have no way. They could look to the online dockets and see some of those things if the person has anything that prohibits them in that regard. But what happens when it's in a different state? What happens when it's a mental health commitment? What happens when it's a PFA? They'd have no way of knowing about it. So usually when I develop membership agreements for my gun clubs and that, there is basically statements akin to that which you would see on that ATF 4473, where the person attests to the fact that they're not a prohibited person. I haven't been convicted of a crime punishable by more than 1 year. I'm not a fugitive from justice. I've not been adjudicated incompetent or committed to a mental institution, yada, yada. Why do that? Well, if God forbid something goes sideways and media finds out that this individual was shooting at the range and they're making a scene of it, the club can go out and say, what more could we have done? Under the law, they preclude us from being able to determine if someone is a prohibited person. We went above and beyond the requirements and even had them issue a statement subject to the penalties of perjury here in Pennsylvania that they weren't a prohibited person. So it gives you some type of cover, more so than what you would have otherwise. Just something to think about. Stand your ground. I know a lot of you have been waiting to hear about this. Do we have a stand your ground law here in Pennsylvania? Yes, we do. We're not going to talk about the castle doctrine, which is in your home or vehicle. We're just going to talk about stand your ground here today because we're generally talking about houses of worship. So there are a number of elements that need to be met, and this is one of those regards where I want to read them because I want you to fully understand them, and then we're going to talk about them. The actor is not engaged in criminal activity. The actor is not in illegal possession of a firearm. The actor is attacked where Pennsylvania would have previously required them to retreat Between you and I, you can just ignore that third one. It makes no sense. The General Assembly included it because they didn't have a firearms law attorney advising them. 4, the actor had a right to be in the place where attacked. The actor believes it immediately necessary to protect him or herself against death, serious bodily injury, kidnapping, or sexual intercourse by force or threat, and the person against whom force is used uses or displays a firearm or replica thereof, or any other weapon readily or apparently capable of lethal use. Okay, let's talk a little bit about each one. The actor is not engaged in criminal activity. We don't want the gangbanger or drug dealer to be able to assert stand your ground against a law enforcement officer. So you can't be involved in some form of criminal activity. You also can't be a prohibited person in possession of a firearm. Makes sense. Also, where you're being attacked, this is the one that I said has no real meaning because you would have previously required them to retreat. Quite honestly, that was everywhere where stand your ground currently applies. Prior to 2011, House Bill 40, when we enacted our stand your ground doctrine, you generally had a duty to retreat if you could do such safely. Again, this is out in public, it's not in your house. 4, actor had a right to be in the place where attacked. Now, I want to take a second to discuss this because it is a concern of mine. There are a lot of people that I know that ignore signage that tells them that no guns allowed, especially in malls and that. They figure, I'm responsible for my own protection, I'm going to carry, even though I know, generally speaking at this point, I'm trespassing. Do you lose your right to stand your ground in that situation? And the answer is, you may. I don't know. There has never been, since 2011, any case law come down on that fourth element, specifically in that situation where someone's trespassing or that. I have some friends who will look at the sign and say, yep, no Berettas, I'm carrying a Glock, I'm good to go. You know, okay, you know, they're discriminatory against Berettas. Just be aware of that. Quite honestly, I don't think any district attorney would even consider prosecuting someone in an active shooter situation where you neutralize the threat. I think that would be political suicide. That being said, you never know what any one district attorney is going to do, and they could want to make you be their political agenda. So just keep that in mind. 5th, the actor believes it immediately necessary to protect him or herself against death, serious bodily injury, kidnapping, or sexual intercourse by force or threat. That's pretty clear. I don't know that we really need to spend any time on that aspect. This last one always generates questions, a lot of questions that I have to say, I don't know. Person against whom force is used displays the firearm. Well, that's pretty easily, or a replica thereof. There's no real question about that aspect. Or any other weapon readily or apparently capable of lethal use. What is that? We talk about disparity of force when I do seminars and that, meaning it might be myself against 2 assailants. Well, are they now capable of lethal use because of it being 2-on-1? Maybe, maybe not. What happens if I'm 1-on-1 with Jackie Chan? Are his hands lethal weapons? Maybe, maybe not. I don't know. There's actually a case pending right now against Nike. I think it's still pending, where this guy gets convicted of aggravated assault because he used his Nike shoe to beat someone. He's now suing Nike, saying they never disclosed to him that the shoes he was purchasing could constitute lethal weapons for a sentencing enhancement. You know, so what constitutes a weapon? I don't know. I can't definitively tell you. I feel pretty assured that if I have a 70-year-old man up against a 20-year-old young man, there's a pretty damn good argument that that 20-year-old's body is a lethal weapon in comparison to the 70-year-old man. But we don't have any case law on that. And also, while there have been pushes to enact a bill that would discuss disparity of force, it's hard to think of what language would encompass it all. And what I mean by that is, let's say they say, well, you know, a 90-pound woman should be able to use lethal force against a male who is 180 pounds. Okay, so now if she's 92 pounds, she's not eligible to use lethal force in that situation? I mean, that's the absurdity that you get into when you start to try and figure out how to write a bill to be so encompassing to protect in those situations, but then you get led astray by these absurdities. You can never really truly write something, at least that I've seen yet, that really encompasses a disparity of force situation. Even if you do percentages of body weight, I mean, how do you know how much the other person weighs? You don't. So keep that in mind. That's the biggest question. Usually when I do the seminars at the end, everyone has, well, what if I'm in this situation? What if I'm in that situation? Unfortunately, I can't definitively tell you, because it's always going to come down to that exact situation, what you know about that other person, all sorts of information like that. What about with third parties? Can you protect third parties? Yes. Here in Pennsylvania, if you would have legal right to use lethal force in the situation that that third party finds him or herself in, you can basically use lethal force on their behalf. So we do have that protection under Stand Your Ground here in PA. Also, there is the element, the last one, the actor believes that his intervention is necessary for the protection of such other person. Notice it is the actor's belief. It's not a reasonable person's belief. It's not a third party's belief. It is that actor. So as long as it was reasonable for that person, under their belief, to need to use lethal force because they believe the situation was such that warranted it, that person is authorized. Now, we have a little bit of time, enough time that I can go through what I like to do during a use of force portion of our seminar. I call it the burger joint example. You're going to go home and you're going to apply it to your houses of worship, your bank, every location where you find yourself in generally, because it is amazing to me how few people plan for a potential incident and what they're going to do in that scenario. And at certain points during this, when I give this kind of spiel, it's amazing how the air kind of leaves the room. Some people are taken aback with things that they never thought of previously. So I'll set the scenario. You're at the burger joint with your family. Say you're there with your wife and 2 kids, and some perp comes in and puts a gun to the clerk's head. What do you do? Now remember, you only have seconds. You can't be thinking about this. You need to know what you're already going to do at that point in time. Come on, time's ticking. What are you doing? Clerk's dead. Little did you know, she had a little baby girl, 3 months old, waiting for her to come home that night. Little baby girl's never going to see mom again because you took too damn long. All right, rewind. Perp with the gun to the clerk's head. What do? Let's say you say, my loyalty and duty is to my family, to get them out to safety. That's fine. No one in this room can judge you for that decision. So you take your family out back and you get them out safely. Now what? Are you going back in, or are you staying out with your family? Bang. Clerk's dead. Took too long. You don't have the time to think this out in that situation. You need to know how you're going to react. So let's say you decide to go back in. Well, little did you know, there's a getaway driver, and they all agreed no one was leaving there alive. You just left your wife and 2 kids out back, alone, unarmed. Or did you? Maybe you've prepared for this situation, and so your wife has training. Maybe she has a firearm herself or other weapon. Maybe depending on the age of your wife and children, you've developed a plan where you scatter into the wind in that situation. You all have a rendezvous point where you're going to come back to after the threat is dealt with. Again, it's going to depend on age of the children, and it's something you have to develop in advance. You need to know what you're going to do in that situation. So you go back in, and you got the perp standing there with the gun to the clerk's head. What do? Come on, time's ticking. Let's say you decide to shoot, and you miss, and you kill the clerk. Can you live with yourself for the rest of your life? This is a serious question. You need to know the answer to this question, because I don't care how much training you get, there is always the possibility that no matter who pulled that trigger, the same thing would have happened. You could have had a squib load in your gun last time that you didn't know about, and this time it pushes it out on an angle, and guess what? That's the round that hits and kills that clerk. Can you live with yourself? It's a possibility, no matter how much training you've had. Now, if that didn't make the air leave the room, what happens when the perp turns around to you and it's your son, or your daughter, or your uncle? Are you prepared to use lethal force against a loved one? And if you tell me, Josh, Lion's Sand is there and you're over it, that's fine. No one in this room can judge you for the decisions that you're going to make. But you need to know what the decision you're going to make is going to be before you find yourself in that situation. And it's okay, as I said before, if you say, family members in that, even if they're, off their rocker, I'm not going to use lethal force against them. That's fine. You need to know that, though. When I do these seminars, I always feel inclined to let people know what my own personal decision-making is in these situations, and my own personal decision-making, not that it should influence any of you, is that I am going to do whatever I can to save any life, provided I believe there is some, even remote, possibility that I can save that life. Doesn't matter race, creed, religion, none of that factors in for me. For me, the only factor is, do I think I can save their life? Doesn't matter if it's a 90-year-old woman and I'm potentially jeopardizing my life. I'm going in, I'm going to do whatever I can do to try and save that person if I believe there's a possibility for that. But that doesn't mean it's the right decision for you. You'll note, there's no ring on my finger. I jokingly say I'm married to my work. And to some extent, it's true. If I got married, would my decision change? Maybe. You have to be open-minded enough to know that as things change in your life, the decisions you would make in any particular situation may evolve. They may change. And you need to constantly reassess them so that you know what to do in that situation and not be taken by surprise thinking, oh my God, a month ago I got married, do I want to really put myself in this situation? Again, no one can judge you for the decisions that you make as long as they're lawful ones. So, with that being said, let's move on a little bit now that I took the wind out of everyone's sails and talk about our last topic, civil immunity here in the Commonwealth. Is there civil immunity? Yes, technically there is. But if you leave here with anything, and I hope you leave with a lot more, understand anyone can sue anyone for anything. All right? There is no ability to preclude someone from initiating lawsuits or an action against you. Anyone can sue anyone for anything. But the law does protect you in the event that you are using lawful force. So what it says is if a lawsuit is brought by the perpetrator and dismissed, the court shall award reasonable expenses to the actor. Reasonable expenses shall include, but not be limited to, attorney's fees, expert witness fees, court costs, and compensation for loss of income. So what that means in a nutshell is if you are sued as an organization or as an individual after you justifiably used force, the court is supposed to dismiss the action and then award you your attorney's fees, costs, and everything else. Of course, I'm sure most of you are thinking about the fact that, well, this person was probably robbing me or something like that, so it's not like they have deep pockets or any pockets at all, which is a concern. The fact that the law says you're to be reimbursed by that person who brings that basically frivolous action, you got to realize you can't get blood from a stone. There are a number of insurances out there and prepaid legal services that you may want to consider. We haven't touched on the issue of discussing this with your insurance companies. That's a whole separate discussion. And, I know some of you take the thought process of, well, we won't mention it, we'll deal with it if it becomes an issue. Quite honestly, that's the wrong approach to take, because the last thing you want to do is find your organization in that type of situation and for the first time be learning that, oh yeah, there's no insurance coverage, and you have multiple lawsuits coming out of every direction. Does it mean that your insurance will cover you? No, it doesn't mean that whatsoever. You need to discuss with them what their restrictions are, and maybe there's a rider that they offer for that situation. Maybe there's a different insurance that's out there that you can work with just for self-defense situational shootings or such, where you have your regular insurer for general casualty and incidents and such like that, and have additional insurance where, God forbid, you have to use lethal force or some form of force on someone, and there's a lawsuit that results. As I said, there are a lot of topics that we could discuss today that are directly relevant to houses of worship, but we only have limited time. So again, I would highly recommend that you make sure to obtain counsel with these issues, get determinations like the private detective's license issue from the district attorney, work with local law enforcement where possible in relation to these issues, even if they have any forms of security that they offer. I know in Berks County, during several of the high holidays, the synagogues do have police that are offered by the local police department to be there. That might be a resource that you want to consider. You may want to have discussions with your local police department in that whether they have any allocation for officers during either high holidays or just regular services. It's at least something more than you may have currently. Also, as I alluded to earlier, I truly do not believe any one of you can determine whether or not someone is prohibited. And that is why I would highly recommend, if you are going to have an actual security force of one nature or another, that those individuals be Act 235 certified. But that comes, as we discussed, with a cost.